Well, how do you feel about vaping that's being marketed, obviously, to children and teenagers with flavors like peachy strawberry and cookies and milk? Well, if you think that should be illegal and inappropriate and be banned from the market, then you would agree with the Food and Drug Administration, who did exactly that. Yet, we have a major oral argument at the United States Supreme Court on Monday, on December 2nd, about whether the FDA was right or wrong to ban such marketing, obviously directed to children and teenagers, about products that contain tobacco and nicotine. I'm here. Legal AF, the YouTube channel. Take a minute, hit the free subscribe button, and I'm Michael Popok, and I'm at the intersection of law, politics, and the Food and Drug Administration. Now, this is also going to drag in Donald Trump through his the person he'd like to see run the Health and Human Services Department, because the FDA reports to HHS. Follow this logic. In addition, right now, the case is being argued by the existing Solicitor General's office under Joe Biden, and that is not who's going to be the Solicitor General in the next 60 days. That's going to be John Sauer. So, but right now, we got cases to argue, and it's cases going forward. And the issue on appeal on an emergency application to the full United States Supreme Court with oral argument is, did the FDA comply with its own rules and regulations to ban this type and deny this type of marketing to children as a public health hazard? If they did it properly and not arbitrarily and capriciously, then the Supreme Court will overturn what the Fifth Circuit Court of Appeals ruled was an arbitrary and capricious application of their rules and regulations, allowing this type of flavored vape with titles like milk and cookies, flavors like milk and cookies, to go to the buying market, wink, teenagers and children. And look, the tobacco industry, who owns and controls these kind of vaping companies, they market it as, you can taper off of cigarettes. You can wean yourself off cigarettes. It will cure your cigarette habit. Right. And instead, you'll develop a vape habit because there's nicotine in it. In fact, every generation of vape, every vape delivery dispensary system, has had more nicotine in it by percentage than the system before it. They get more addictive, not less, over time. And so why are we here? Because there is a circuit court, an appellate court of the United States called the Fifth Circuit. Sits in Louisiana, covers Louisiana, Texas, and some other states. It's where many of the right-wing MAGA federalists and their judges sit, in the Fifth Circuit. That's why Donald Trump and MAGA and Tesla and Musk continue to file cases in like Eastern District of Texas to get a favorable ruling from a MAGA judge who sits there, over to the Fifth Circuit for a favorable ruling from a panel. There's approximately about 20 judges in the Fifth Circuit, most of which, I think 9 or 10, have been appointed by Donald Trump. It leans over to the right. And that's why more cases come out of the Fifth Circuit and get up to the United States Supreme Court than any other circuit combined. Any other circuit. 6 or 7 cases already this term for the United States Supreme Court are coming out of decisions by the Fifth Circuit. And all of the judges there are trying out, if they're in their 40s or early 50s, for a United States Supreme Court vacancy should one open under Donald Trump. One of them is Judge Ho, and the other one I've talked about at length is a guy named Andrew Oldham. He is trying out hard. He wants the Supreme Court opening, should there be one, a lot. And he's been writing all of these decisions and injunctions to undermine things like public health and safety and food safety and the rulemaking of the Food and Drug Administration. Now, the reason I am worried about Monday's oral argument is because it came on the heels of the Supreme Court ripping out of the books a 50-year precedent. No, I'm not talking about a woman's right to choose. This is something else. They ripped away a 50-year precedent that we refer to in the law as the Chevron doctrine, which meant that courts, federal courts, should defer to the reasonable interpretation of rules and regulations of the industry experts and the regulatory experts for an administrative body or administrative regulatory agency or department that's charged with regulating that area. So you defer to the scientists that know what they're talking about for clean air and clean water and nuclear regulation, and here Food and Drug Administration. That was on the books forever. That was the starting point. Right-wingers and federalists and MAGA hated that because it gave too much power, in their view, to the administrative state. And they hate the administrative state. They want all power to be reposed and rested in and invested in the presidency, the executive branch. They hate the things that come along with the executive branch, which is the administrative branch, which regulates and touches our day-to-day lives. So they overturned the Chevron decision in a case over the summer that got little attention, although we covered it heavily on Legal AF, called Loper-Bright. We call our cases under precedent by one of the names of the parties in the case. So in the Loper-Bright decision, sometimes we shorthand it, in Loper-Bright, they overturned 50 years of precedent, and they found that federal judges do not have to give and should not give any deference to how to read a regulation to the experts in that industry. These judges who barely passed science class are now going to be the overlords over regulation in scientific-based and technology-based areas they have no understanding of. That's what happened. And my concern, as I started this segment with, is that they right after they overturned the Chevron decision, which undermined and diminished the power of agencies to regulate their industries, that's when they granted the appeal to have the FDA's decision-making about marketing to children considered by the United States Supreme Court. Coincidence? I don't think so. I think the Supreme Court, now emboldened, will try to use the Loper-Bright decision overturning the Chevron doctrine to rule that the FDA overstepped their boundaries, were arbitrary and capricious, were not consistent with applying their own regulations, and that therefore candy-flavored vape can be marketed to children. I mean, there's no other way for me to put this. The Fifth Circuit Court of Appeals, which is the lower level appellate court from which this Supreme Court is taking the case from, ruled in what we refer to as an en banc decision, meaning all the judges that were available at the Fifth Circuit heard oral argument, and the majority wins. So there were 16 judges. Picture this. I've done oral argument, not en banc, but I've done oral argument to a group of 5. There's 16 judges sitting in rows. And like we have 9 on the Supreme Court, but there's 16 here in this Fifth Circuit. It was argued on October 26th of 2024. It just happened. And during it, they heard argument about, from the vaping company, whose this case is now referred to as Triton, Triton. It's also known as Wages and White Investments, but it changed its name to Triton. So we call it the Triton case. The Triton lawyers were there, and on behalf of the government, it was the Deputy Solicitor General, who's the one under Biden, not under the former criminal defense lawyer for Donald Trump. You see how this is like a moment in time that's very unique. We're in the lame duck period for Joe Biden. Everybody's lame duck, but the case goes on. And so they're going to argue, and they argued at the Fifth Circuit before the panel, that the Triton people argued, it's arbitrary, it's capricious, there's no public health concern, we're not really marketing to children. I mean, even adults like peachy strawberry and cookies and cream, don't they? I'll just leave that for a second for you to cogitate about that. FDA, represented by the Solicitor General's office, was like, no, this was public health. This is obviously that they're marketing, and it's a known and substantial risk of public health being undermined and children's health being undermined because of the marketing. These are nicotine products. This is tobacco. This is what the FDA is permitted to regulate. And these were proper. They have a structure within the Food and Drug Administration where all this kind of advertising and promotion and marketing has to go through this approval process. There's 2 parts of it. There's the pre-market tobacco application process, the PMTA. And then there is the marketing denial orders, MDOs. And this was a marketing denial order. No, you don't get to market to children these flavored vapes. And this is what the appeal was. But at the Fifth Circuit, 10-6, 10 judges said, nope, market to children. MAGA's like, kill our children. That's fine. We don't care. Kill the nation's children. That's fine. And then they got a injunction to stop the FDA from banning it. I think it's being marketed right now. And then got picked up by the Supreme Court. But again, tricky. They waited until they ripped away a 50-year precedent that will be of assistance to the vape companies before they hear oral argument on Monday. So what I'm looking for, and I'm going to listen to oral argument, and we'll do an update of this case on Unprecedented, which is our weekly Supreme Court roundup analysis show that I do right here on Legal AF, the YouTube channel with Dina Dahl. We'll pick up with it after we listen to the oral argument on Monday. I'm looking for MAGA. I'm looking at you, Gorsuch, Alito, Thomas, maybe joined by Kavanaugh or Roberts, somehow sticking it to the FDA, calling it, and I've seen this in other right-wing judge opinions about this matter, calling it Kafkaesque and as the old switcheroo is what Judge Oldham called it in the Fifth Circuit case. And we'll see early on how the sides align here in oral argument. I think you're going to see Sotomayor, Kagan, and Ketanji Brown Jackson supporting the FDA. You're going to see Alito, Thomas, and Gorsuch attacking the FDA, maybe joined by Kavanaugh and Roberts and Amy Coney Barrett, who is quickly becoming the center and holding the center because she's center-right, not MAGA on most issues. We're going to have to see where she is. If I was the advocate representing the FDA, which is going to be the Deputy Solicitor General under Joe Biden, if you will, under the current Solicitor General, I would aim for Amy Coney Barrett, try to get her over and try to pick up one more vote. You count to 5, you got to win to overturn the Fifth Circuit Court of Appeals and get these products, obviously filled with nicotine, marketed to children and teenagers, off the market or deny them from being marketed. That's what we want to do. So that's what we're going to have to watch on that oral argument. I'll continue to follow it right here on Legal AF on this YouTube channel. Hit the subscribe button. It helps. And then if you like this stuff at the intersection of law and politics, where we don't blow smoke or sunshine, we just tell it to you straight so that you understand it. We try to simplify complex things, but not dumb it down. You've come to the right place. Legal AF, the full-length podcast, Wednesdays and Saturdays, forgot my day. Wednesdays and Saturdays, 8 p.m. Eastern Time on the Midas Touch Network. I'm doing Popok Live with legal updates on the Midas Touch Network on Tuesday nights at 8 p.m. And then all the other hot takes and work over here on Legal AF, the YouTube channel that we do in collaboration with the Midas Touch Network. So until my next contribution in the world of Legal AF, I am Michael Popok, and I am reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.